Hey everyone, Harry here to talk about the U.S. Supreme Court parachuting in to a lawsuit involving Virginia voter registration to now permit that program to go forward, or at least the continued disenfranchisement of some 1,600 Virginians. All right, so first, this is of a piece with Republican schemes in other states trying to leverage a phantom allegation that non-citizens out there somewhere are voting in order to trim back the rolls substantially. So the governor, Glenn Youngkin, ordered a review of the rolls of citizens and purge voters whose registration doesn't line up precisely with DMV records. Now, the notion here is that somehow that's a strong indication that they are non-citizens voting. It appears, and from everyone who's looked at it, including in lawsuits where Republican officials have had to testify, that this is a problem that just isn't happening out there, and rather it's ensnaring people who didn't cross their T's and dot their I's on DMV stuff, and others who are just, as far as anyone can tell, they should have been permitted to register and they weren't. Nevertheless, Youngkin orders this and it goes to a district court which enjoins it, says you can't do this on the basis of a 1993 federal law that still is in place. The court has radically pared back on other voting rights laws, but this one is still there, and it prescribes a quiet period for the last 30 days before an election during which you can't do any sort of systematic purges. Based on findings by Congress, they tend to be chaotic. They're very hard to, you scramble the eggs and can't unscramble them. And indeed, that's what the idea would be here. It's what happens as of the election. The district court said the 1,600 are back provisionally, and then it went up to the Fourth Circuit, which declined to enter a stay and therefore keep the district court's order in place. And then the U.S. Supreme Court, in a unsigned order this morning along straight party lines, 6-3, granted Virginia's request to put that order on hold while a challenge continues. That's the notion. We're just staying it now on an emergency basis while the challenge continues. But of course, this is the tail wagging the dog, because the question is, what is the state of play for this coming election? They will later adjudicate this and probably find out that very few of the 1,600 should have been prevented from voting. But now that the court has entered this order freezing what the district court has done, we're back to where Youngkin was. Now, look, it's not just that there's very little evidence that non-citizens are voting here. Non-citizens who vote are subject to criminal charges and deportation. There's very little reason to think that non-citizens would somehow be trying to sneak in there and vote. And the state, if it knows that a non-citizen is voting, as opposed to this sort of speculation involving very, very threadbare evidence that the DMV records just don't precisely match up, the state can tell an individual voter, or an individual non-citizen or otherwise ineligible voter, you can't vote. So to the extent it's a problem here, it's only a problem that requires the state to do its homework better. Whereas what they really want to do is use a wide net to cover all kinds of people as to whom there's some arguable discrepancy based on DMV records, which themselves are notoriously unreliable. Okay, The Biden administration supported the lawsuit here that tried to enjoin the governor, who, again, he had directed the State Department of Motor Vehicles to provide state election officials with data on a daily basis to allow them to identify and cancel voter registration of quote-unquote suspected non-citizens, unless those suspected non-citizens could somehow verify their citizen status within 14 days. And that was, like, you got to come in within 14 days and get this straight. It's almost like applying for a new driver's license. Anyway, the basic legal issue is that this was a violation, says the Biden administration, of the quiet period provision of the National Voter Registration Act. And it was on that basis that the district court said, look, you can't do this. You can still remove them on an individual basis. But the argument that apparently prevailed in the U.S. Supreme Court, we don't know because it's an unsigned order, is that Virginia came in and said, this isn't really a systematic program. It's an individualized program. And in what sense? Well, you get data every day, individualized data about which voters registration don't match up exactly with DMV, and that's an individualized program rather than a systematic one. That seems to make the difference between systematic and individualized pretty trivial, or just to negate it all together. But that's the argument that Virginia made, and the Department of Justice, the Solicitor General, said no, this is the quiet period, and it only applies in the run-up to elections. So it's precisely the kind of systematic program that the quiet provision bars. They just created this list of suspected non-citizens who were then compared electronically to information in other agency databases without any real case-by-case consideration at all. And that seems to really undermine this argument that it was somehow an individualized and not a systematic determination. Nevertheless, Supreme Court 6-3 says that that's the ball game, that it presumably that it was not systematic. Don't know of any other basis that was up there. And now, though, that chunk of voters are not going to be eligible to vote by Tuesday. And I think even the time for them to have come in and corrected it is gone anyway. So this non-citizen phantom allegation serves the purpose that Virginia's governor wanted it to do, as a leverage to keep a lot of people, almost surely the vast majority of which are perfectly eligible voters, from voting come Tuesday. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.